Good afternoon. My name is Teresa Cusick, and I am a project specialist with the Nebraska Court Improvement Project. And before I introduce the speakers, I will cover a few housekeeping items. All attendees should be muted and their cameras off, but if not, we would ask you to do so. During the presentation, questions can be asked in the chat box, which will be answered at the end of the presentation. This webinar is being recorded and can be located on the CIP YouTube channel early next week. And the webinar has been approved for 1 hour of CLE credit, and the activity number will be shared at the end of the presentation. We are thrilled that so many folks are attending today's webinar, and I specifically want to thank representatives of the tribal courts in Nebraska who are in attendance. And it is a pleasure to introduce today's speakers. Teresa Rachel is the Attorney General of the Omaha Tribe of Nebraska. She's also the tribe's acting prosecutor and presenting officer. Jonathan Seagrass is the Managing Attorney of Legal Aid of Nebraska's Native American Program. Thank you both for presenting today's webinar, and I will turn it over to you.
John, I think you're on mute.
Thanks, Teresa. And I just said, thanks to Teresa for that introduction. And we'll echo that, I'm so excited so many people have logged on to hear, I guess, what we have to share today. And I think that my screen is shared. Somebody, let me know if that's not the case. And I guess, like was already said, I'm Jonathan Seagrass, and I am the managing attorney of Legal Aid of Nebraska's Native American Program. I've been an attorney since 2009. My entire career has been with Legal Aid of Nebraska's Native American Program. And the Native American Program is a unit here at Legal Aid of Nebraska that provides targeted legal assistance to Native Americans across the state in both state and tribal courts. Teresa, anything you want to add about yourself before I dive in?
Sure. Before I practiced here in Omaha, I was also the presenting officer in the Winnebago court, and I've practiced in basically child and family services type cases since I began practicing law in 2013.
I think, just to talk a bit about where we're headed and what to expect, I'm going to give a very short 2-slide overview of the legal status of Native nations, kind of a very bird's eye view of federal Indian law. I'm going to talk about, tribal courts in Nebraska, what they are, where they are, what they do, and share some information about how a person can become licensed to practice law in the 4 tribal courts in Nebraska. And then we're going to dive into an overview about tribal child welfare. And I think when we get to there, the general plan is I'll hand it over to you, Teresa. So I guess here we go. So I think the reason why we wanted to cover, some information about the legal status of Native nations is I think that that's always helpful, or at least informative, to put into context the issues that we're going to cover in this webinar, or whatever issues, legal issues that certainly I'm talking about when it comes to Native American tribes. There are 574, I think is the current number, federally recognized Native American tribes in the United States. And the place I always start with is to recognize that Native American tribes are sovereigns under federal law and, of course, under tribal law. And what this means is that tribes have that uniquely sovereign ability to make their own government and laws and to be governed by them. And also, I think it's important to note that tribal sovereignty is inherent to the tribes, meaning that tribal sovereignty has not been given to the tribes by the federal government or anyone else. It's something that tribes have always possessed, modified in some respects, but unbroken through to today. And the federal government has a complicated process of determining whether to recognize that sovereignty for a certain tribal group. And the federal government continues to recognize previously unrecognized tribes. But as I said, my understanding is that the federal government recognizes the sovereignty of 574 Native American tribes currently. And the second thing that I think is helpful in understanding the legal status of Native nations is to just spend a moment to consider what the legal foundations are for the relationship between the federal government and tribes. I'm an attorney. Of course, Teresa's an attorney. I think many of us on the presentation may be attorneys as well. I guess, at least I think, in my mind as a lawyer, I think of the United States Constitution as the foundational legal document from which so much law flows in the United States. But, excuse me, the Constitution doesn't really mention Native American tribes all that much. I think that Native American tribes are mentioned in the treaty clause authorizing the federal government to enter into treaties with Native American tribes, which in and of itself implicitly recognizes tribes as being sovereign. Tribes are also mentioned in the Indian Commerce Clause, in which the federal government is granted the authority to regulate commerce with Native American tribes. And I think that that's about it. And also, while states ratified the United States Constitution, Native American tribes did not. They weren't parties to the Constitution when it was written. And so I think of the United States Constitution primarily as defining what powers the federal government has vis-a-vis the states. And in the next slide, I'll explain a little bit about how I think that's relevant. And then another major source of law concerning and defining the federal-tribal relationship are, of course, treaties. Pursuant to the treaty clause, the federal government entered into and ratified hundreds of treaties with Native American tribes. And, this isn't a presentation on, treaties between the federal government and tribes, but like all tribes, they are the supreme law of the land. They are extant. They are legally binding on the federal government. And in many of the treaties, the federal government agreed to provide various services to Native American tribes. And perhaps suffice it to say, Native American tribes expect that the treaties, require the federal government to meet those promises. And of course, also there are statutes, case law affecting or implementing all of this that I've talked about. The United States Supreme Court, looking at this background, has held for a long time that the federal government, particularly Congress, has so-called plenary power to enact laws affecting Native American tribes, including to define the extent of both tribal and state sovereignty in matters concerning Native American tribes. I also anticipate, there's probably, some people who aren't lawyers or people who maybe aren't familiar with, federal Indian law at all. If I didn't do this work, I might hear the word plenary and really have no idea what that means. And at least the dictionary definition is unqualified or absolute. And that's not a legal, definition of the word, but I think that, gives a sense about, what that power is. It's, spoken of as being absolute power. And generally, however, the federal government's plenary power is to the exclusion of state state authority to regulate Native American tribes. My Indian law book here in my office mentions several exceptions to that, which I'm not going to get into, but generally, I mean, that's the generally applicable rule. Because the federal government has plenary power concerning Native American affairs, and because the federal government has entered into treaties with Native American tribes, tribes have a direct government-to-government relationship with the federal government, meaning that they work directly with each other on issues affecting the tribe. And the federal government has an obligation to consult with Native American tribes when doing things that affect tribes. And to steal a phrase with, I mean, the great power that the federal government has comes also with great responsibility. And the treaty obligations, other law enacted over the history of the United States has collectively come to be referred to as the federal trust responsibility that the federal government has concerning Native American tribes. The federal government has obligations to tribes and individual Native Americans, which are very important to Native American tribes and their members. One way that the federal government attempts to meet those obligations is by appropriating money, whether it's to the Bureau of Indian Affairs, Indian Health Services, the Department of Housing and Urban Development, increasingly directly to Native American tribes. But of course, many would claim that the amount appropriated, over the years, including today, really has never been sufficient to actually meet the obligations that the federal government has promised to do. And so there you have it, my 2-slide overview of federal Indian law. And I guess now I'm going to shift into talking about the tribes in Nebraska and tribal courts in Nebraska. There's 4 tribes headquartered in the state of Nebraska: the Omaha tribe, the Ponca tribe, the Santee Sioux Nation, and the Winnebago tribe. And this map of Nebraska shows, I guess, what part of the state, all of these tribes are active and present in. There's 3 Indian reservations in the traditional sense in Nebraska. The Santee Sioux Nation, hopefully this is big enough for those of you on your screen, they have a reservation in Knox County, bordering South Dakota in northeast Nebraska. The Winnebago tribe has a reservation occupying much of the northern half of Thurston County, also northeast Nebraska, and the Omaha tribe's reservation is located in generally the southern half of Thurston County. The Ponca tribe of Nebraska was a tribe whose federal recognition was terminated by the federal government during the termination era in the 1950s and 1960s. And so for a period of time, roughly between 1960 and I think 1990, the federal government did not consider the Ponca tribe to exist. In 1990, Congress passed the Ponca Restoration Act, restoring federal recognition to the Ponca tribe and establishing what is known as the Ponca Service Area, which is 15 counties, mostly in Nebraska, some in Iowa and South Dakota, where if you are a member of the tribe residing in one of those counties, I think the act says you are considered to be as if you were living on a reservation for various federal purposes. I do want to point out that there are other tribes that have land that extends into other parts of Nebraska. I believe the Sac and Fox tribe and the Iowa tribe, both headquartered in Kansas, their reservations extend into parts of Richardson County in extreme southeastern Nebraska. It's also my understanding that the Oglala Sioux tribe, whose reservation, the Pine Ridge Indian Reservation in southwestern South Dakota, also has a small portion that extends into extreme northern parts of northwest Nebraska. And all 4 of the tribal courts, or all 4 of the tribes headquartered in Nebraska, also have tribal courts that they have established to be the courts of the tribe. They all, with the exception of the Ponca Tribal Court, exercise both civil and criminal jurisdiction. The Ponca tribe presently only exercises civil jurisdiction, and those courts are established pursuant to each tribe's constitution and tribal code, and their powers are defined in the tribe's constitution and their tribal codes. Those legal authority, the constitutions and the tribal codes, are generally available online and accessible to anyone, anywhere. The Omaha tribe, the Ponca tribe, and the Winnebago tribe, they all have their constitutions and codes posted to the tribe's websites. And we've provided the link to those websites here on the slide. The Native American Rights Fund maintains something called the, I think, National Indian Law Library. And in that library, there is significant portions of the Santee Sioux Nation Tribal Code. I'm not certain. I didn't check. I don't know if their constitution's on there as well. But I mean, in many instances, these websites are updated if there's changes to the code. But I don't think that that's always the case. So if you're practicing in tribal court, or if you need to know, what the current state of, the tribal law is, I think it's always good to check with the tribe or the tribal courts for the most up-to-date versions of the constitutions and tribal codes. The Ponca Tribal Court and the Winnebago Tribal Court, they both have websites of their own, which contains more information about those courts. The Ponca tribe, for instance, they keep a list of attorneys that are licensed to practice law in tribal court, updated on their website. Both of these courts have links to forms that litigants can use to, file certain types of cases or, request certain things, similar to what exists on the Nebraska Judicial Branch's website, where they have all those forms that are publicly accessible. And it's generally pretty easy, in my opinion, to become licensed to practice law in any of the 4 tribal courts in Nebraska. Generally, if you are an attorney licensed to practice law in any jurisdiction in the United States, including tribal jurisdictions, you are eligible to become licensed in one of the 4 tribal courts in the state of Nebraska. And generally, all that is required is that you are an attorney who is an active member in good standing in one of those jurisdictions. And you need to submit an application, take the oath that each tribe individually requires of its attorneys, and pay the admission fee. I've heard and know it's the case that some tribes in other parts of the country, some of them have like their own bar exam and things like that. Thankfully, at least for me, that's not the case in Nebraska. I guess something that is, to some extent unique to tribal courts vis-a-vis like Nebraska state courts is they allow lay counsel, which would be somebody who isn't an attorney in good standing in some jurisdiction in the United States. Those people can also become licensed to practice law in the 4 tribal courts in Nebraska. The specific requirements vary. I think that the Winnebago Tribal Code requires lay counsel to have completed a paralegal certification course or something similar. We've been successful in getting like law students, licensed to practice law in the Winnebago Tribal Court, or people who, are waiting for their bar results, arguing, well, law school is, similar to a paralegal certification course. And the application process to become licensed as lay counsel is very similar, I think almost identical to that of if an attorney were to request to be licensed to practice law in tribal court. there is in the Omaha Tribal Code, the Santee Sioux Nation Tribal Code, and the Winnebago Tribal Code, something that says, if you're licensed in one of those tribal courts, you are agreeing to perform, some number of hours, minimal number of hours of pro bono assistance in a case that the court might appoint, that attorney to. I think that I, I don't know the specific number. I think many of the codes say it's like 10 or 15 or 20 hours a year that you would be agreeing to, and no more than that. In my experience, I don't know that I'm specifically aware of any instance in which a tribal court has like forced an attorney to take a case that they didn't want to do. Teresa, I guess I've heard that Judge Zendejas might be doing that up in the Omaha Tribal Court. I don't know if that's true or not. You can let us know if you want, but that is a requirement that's in there. That's probably something that attorneys would want to know if they're thinking about being licensed in tribal court. Like I said, it really is easy to complete the application, which generally is 1 or 2 pages long. It's nothing like the application, to sit for the bar in the state of Nebraska or other states where you gotta, give a reference for like every place you've ever lived and things like that. It's really quick. The admissions fee, I think comparatively to, state bars is not that expensive. In Nebraska, I think it ranges between $35 and $100. You include a copy of a bar card, you mail it in, and you hear back in a week or 2 or something like that. All of the tribal courts, except for the Pampa Tribal Court, do require an annual renewal of that license, which includes paying the same fee that was paid to become licensed in the first place. In the Ponca Tribal Court, I think you become licensed, and then you don't have to apply every year. I think your license just remains in place until it isn't for some other reason. And generally, there aren't that many attorneys that are licensed in many of the tribal courts. We try to keep lists here at Legal Aid so that we can send them to people that we can assist of attorneys licensed in tribal court. When we receive those, it's not uncommon for the list to be like less than 10 attorneys. So they're, I know in a lot of rural counties in Nebraska, there aren't always, a significant number of attorneys, in the area able to assist people. But of course, that challenge exists in many of the tribal courts as well. And, one motivation, at least of mine, in doing this webinar is hopefully to promote other attorneys who may not practice in tribal court now to become interested in practicing in tribal court, because I think, of course, there's a need for as many attorneys as possible to become available to the members of the tribe who would have cases heard in the court. And I'll just say a few things really quick about child welfare cases in tribal court, and then I'll hand it over to Teresa. Of course, the law governing tribal child welfare and juvenile justice cases, juvenile court cases, the tribal court is found in each tribe's code. And I think there are links both to the applications that become admitted in the 4 tribal courts in Nebraska, but then also to each tribe's current codes affecting child welfare and juvenile justice cases are also linked on the Court Improvement Project's website for this webinar. And those should be available to anybody on this webinar, or I guess anyone else. And each tribe also has an entity that generally, at least the way I think about it, mirrors the role that the Nebraska Department of Health and Human Services has in Nebraska State Court juvenile cases. They each have their own name, they're listed on the slide. The one other thing that I'll point out is my understanding is that the Ponca tribe in Nebraska does not presently exercise tribal court jurisdiction in juvenile abuse neglect cases. My understanding is they've just elected to be active in state court juvenile cases involving Ponca children. And Teresa, you want to take it away from here?
Sure. Is this the last slide or do I have more slides for me? I don't, do I?
I guess I have this slide, but that's the last slide.
Okay, then let's turn that off and you all can look at me.
You bet.
All right. Thank you. Welcome everyone who chose to participate. I was super excited to hear how many people had signed up. Hope everybody can hear me. I think we did a check beforehand. On one of John's slides, it said the Omaha code is chapter 11. It's actually chapter 12, not a big deal. Just didn't want anybody to be confused by that small typo. So where John left off, I really want to emphasize this. Why should you practice in tribal court? One, we really need you. We would really appreciate the assistance and help here. With lay counsel, I wanted to talk about that really quick. We don't frequently have people come in asking to be lay counsel. Here at the Omaha tribe, we do have a lay defense counsel, and he's been doing that here for about 19 years. He's employed by the tribe, and he basically only gets criminal cases, whether it's juvenile delinquents or adults. And as you can imagine, when we have co-defendants, we have a lot of, he's also an elder in our tribe, so we wind up with conflicts quite a bit. And John's office is pretty strained and stressed to be able to take all of those conflicts. There is a pro bono requirement if you become admitted into court. Like John alluded to, judge isn't just going to force you to take a case that you don't know how to do. If that's not the kind of attorney you are, you don't practice there, you only showed up here because you were doing an eviction or helping somebody with a probate matter, and okay, I had to get enrolled in tribal court, but now they're going to make me do a juvenile case. No. What judge does at this point, the process he's decided is if you are on our list and licensed here and we need to appoint someone that's not our own lay counsel or John's office, judge will send out a letter saying you've been appointed in this matter. Please respond within so many days if you are unable to accept this appointment. And we ask that you do your best to help us in that regard if you do choose to become licensed in tribal court. Why else should you practice in tribal court? It's a pretty informal process. I'm actually sitting in our courtroom right now, but if I were to turn the camera around, you would see it's a small courtroom. We only deal with criminal matters that have jail sentences of a year or less. That's what we are restricted to in criminal matters here. So it's basically misdemeanor type cases. So it's a great place to get some courtroom experience, both in the juvenile court setting, if you haven't done that, and in the criminal setting, as well as, frankly, the civil side of things. One thing that's different in our courtroom is you'll see a lot of pro se litigants. If you come up here for a private case, a lot of the times the person you'll be across from isn't an attorney. It's just the other party. And we try to make the process as informal as possible because of that. We've got a lot of self-help forms that people can come up to the court and use and look at. Clerks are a little more informative than I think clerks are in a lot of places, able to, be careful to not practice law, but answer questions. And then, of course, there's our family service cases. John mentioned the Nebraska Department of Health and Human Services, and that tribes have their own Department of Health and Human Services. They do contract with the state of Nebraska. So a lot of what you see in our juvenile court is very similar. Processes are the same. So I'm going to jump right into that overview of the juvenile court system from my perspective. And I have not practiced in Santee Sioux or Ponca. So if John has to fill any blanks in for us or differences, he can do that. I'm going to start by talking about what are the big differences. One thing is grandparent rights. I'm sure most of you, if you practice in juvenile court, there are no grandparent rights. It's very, very slim and restricted in juvenile court. That is not the case in Winnebago. In Winnebago, the presenting officer actually has to send summons out to the grandparents and let them know that there will be an action involving their grandchild. They don't have to attend the hearing. They're not like required parties like the parents would be, but they are allowed and have a right. And they are a party to begin with. They don't have to intervene. They just already are a part of the process. And that varies by tribal court. Here in Omaha Tribal Court, it's more narrow. It basically says if children are involved with family services, grandparents have a right to visitation. We still use the best interest of the child here. That's not different. But what is different about our best interest, I think the biggest difference would be child placement. In the Winnebago Court, there's a very specific placement hierarchy that is supposed to be followed, and there should be reasons why. If they're not with one parent, they should be with the other. If they're not with a parent, they should be with the grandparent. If they're not with either of those, they should be with a sibling of mom or dad, and so on and so forth. Coming down, I think the last placement option is anyone else who's appropriate. And it's important that that hierarchy get followed. And if it's not, placement can actually, the person who wants that placement can actually come in and ask for a placement hearing saying, hey, this wasn't followed. We want to be heard on this matter. And judge has to hear that person's argument about why they think the child should have been placed with them. Here in our court, if you have in your materials at 1255, a little shorter, a little less specific than Winnebago's court is, but still basically important that the child remain with an Indian custodian. So the list in our court is first a member of the child's extended family, second an Indian foster home licensed, third any foster home licensed, and then fourth an institution for children approved by the tribe and the court. So ours isn't that different than what happens in Nebraska, but it's in our code. It's not just a department policy. It's somebody could come in and say, hey, this wasn't followed. There's not a lot of right of intervention in either tribal courts when it comes to juvenile court matters. There's some codes that say shall or may. There really isn't that leeway in our FS cases. That's family services. Very, very narrow whether or not someone who is not actually the parent or guardian can intervene. They're very protective of the courtrooms. Anyone who is in here has to leave when we have any kind of juvenile hearings, even placement, even grandparents, other family members. They have to go out into the hall, and there'd have to be permission from judge for them to be in the courtroom. They are not public hearings.
Teresa, can I just quick, piggyback on that? I mean, you probably recall, there's a case you and I had in Winnebago earlier this year where I think the statute said, parents, could intervene as a party, but the tribe, under the Winnebago tribe's kinship system, defined, some people other than the biological mother also as the mother. And so I think that allowed, grandparents in those situations, or even like biological aunts of siblings of the parents, to potentially intervene. So yeah, I guess that's maybe one way in which things would differ a little bit. Sorry.
Yeah, really important to note, John. You'll hear this a lot if you come up here and decide to start practicing with us. They'll say, well, he's my aunt. She's my aunt in the native way. Well, what does that mean? Or she's my grandmother in the native way. Siblings across the line of a parent are also considered parents of the child. So those people, would be able to probably intervene, the grandparents as well. And again, Grandparents has another definition. It's not just parents, mom and dad. It's parents, mom and dad, and then their sibling group across that generation. So the definition of what parent means, what mom means, what mother means, what grandmother means, has a different definition in tribal courts. That would be important to know before you come in and start working with us. Another thing that's very, very, very different, and if you've ever had any cases that transferred to tribal court, you're probably aware of this. Termination of parental rights is very, very, very rare in family service matters. Basically, the only time tribal court will terminate parental rights is if the parents say, yes, I want to do that. I voluntarily am willing to do that. There are codes that allow myself as a presenting officer to file for a termination of parental rights under grounds like abandonment and other things that you guys are probably accustomed to. It is our policy not to, unless it would have to be something quite severe. Or again, the parent says, I want to do this so my child can be adopted in state court instead. Well, how do we ever get to case closure then if reunification isn't available? So I'm going to go through the basic nuts and bolts of a case. Oh, you know what? I'm going to back up a little bit. We're talking about differences. What's different before we get to what's the same. After the termination of parental rights, not only do we utilize lay counsel, but no counsel is required to be provided for parents if they want an attorney or they want counsel to represent them, or even lay counsel to represent them. They have to secure their own counsel. Guardian ad litems or CASAs. There is an availability in the code for guardian ad litems and CASAs, again, because we are so limited with the amount of attorneys that practice here in tribal court. There's only a couple of cases where guardian ad litems are kind of automatically appointed, or I suppose a child could come in and ask to have a guardian ad litem appointed to him as well, or the department could ask for such, but we don't have a lot of people to fill that role. And that's really something that I would hope all of you who are listening today would consider. If we had, 50 attorneys sign up tomorrow, heck yeah, a lot of more of these kids would have guardian ad litems, and I think that would help our process improve. So we're asking for that assistance today. But no counsel is required to be provided for parents nor guardian ad litems. It all is a may type statute. It is limited jurisdiction. Winnebago and Omaha have a little bit of a difference with the jurisdiction, but we can't, sorry, my phone is giving me a message. It's not just any child that resides on the reservation. It does have to be an Indian child, and there's specific definitions of what that means. They have to either be enrolled or eligible for enrollment in the Omaha tribe or another federally recognized tribe. With ICWA transfers, if any of you have ever had an Indian child welfare case transfer to our court, there's one thing I really, really, really want you guys to hear. I think there's an unfortunate misnomer in state courts that will get transferred to tribal court and then they just get sent home and the case is over. It's absolutely not the case. We have a Department of Health and Human Services that works case plans just like anywhere else, goes out and visits children, follows up with parents and placements of whether or not they're getting to their services, whether or not it's safe to return children. A lot of these cases, children stay in placement for a very long time, and the way the cases end, instead of the termination route, is a couple of things. One, obviously reunification, yay. That's what we always are hoping for. And we have the same obligation to still provide reasonable efforts for reunification. Same thing, you have to do that. But if that is not going to happen, the way the cases end would then be through a guardianship here in tribal court. Or so there can be guardianship, subsidized guardianship. Those subsidies actually come from the state of Nebraska through that relationship our Department of Health and Human Services has with them, so that there is a stipend available, or customary adoption, and technically adoption sometimes. Customary adoption, the difference, instead of a termination of parental rights, there is a suspension of parental rights. Kind of, they could still come back, but it's a very high burden for them to be able to undo a customary adoption. Guardianship, a little lower. Parental rights aren't suspended. They're just given over to the guardian, right? So the guardian then has the rights to care for that child, but a parent can come in at any time before the child turns 18 and ask to have the guardianship dismissed, and parents have the child returned. And it's not just automatic, it's the same process where you have to, go through and prove that they have done what they need to do to have the children returned. And usually when we have guardianships terminated, it's more like the guardian came and said, hey, mom and dad are doing really great, we're ready, to have this guardianship terminated and have these kiddos go home. It's not usually a fight where the parents coming in and saying, I want these kids back and I want them to be taken away from their guardian. Not that that never happens, but that's not the usual case. All right, so now I'm going to get into what is similar in these cases here in tribal court compared to what you're probably used to in state court. Removals can only be accomplished by law enforcement or a court order. There's always an unfortunate misnomer that Department of Health and Human Services removes children. They're always there, they're always present, they're always part of the process unless it's an emergency, but they are not actually removing the children. So that is the same here. Like I mentioned earlier, we use the best interest of the child standard for everything. And we still do initial appearances, adjudication, disposition, permanency, and on occasion placement hearings. One thing with permanency can be kind of undone and backed up. Sometimes we get to a permanency hearing and the permanency objective changes to guardianship. We're no longer trying to reunify. We are now going to have our permanency objective be guardianship. Come back 3-6 months later, parents are doing great. They're doing what they're supposed to, even though the objective was changed. They kicked it in gear. Judge will frequently be willing to return to reunification for the permanency objective. I don't know that I ever saw that happen in state court. But I will mention I practiced mostly over in Iowa before I took this position over here in juvenile court. So maybe Nebraska, it's a little different if they do that very frequently. But at the initial appearance, judge goes through the same kind of rights that you see over in state court. We have very few adjudications that are contested. I would say mostly we work out something that works for everybody, but I have had the chance to have a couple of contested adjudication hearings. Disposition, same kind of requirements where the Department of Health and Human Services has to have a case plan submitted. They have to continue to provide reports. That case plan has to have been reviewed with parents and signed off on. Unfortunately, like everywhere else, when we have parents that are struggling to care for and raise their children, sometimes the department has a hard time tracking them down, just like anywhere. And so occasionally we have case plans that don't have parents participating. Permanency, gosh, one big difference with the permanency hearings from my perspective is that we get a lot more time. I know in Iowa, permanency can be as early as 6 months, 6 months after the case started. Well, gosh, if we're dealing with somebody with methamphetamine issues, 6 months, it's hard to be at the reunification stage then, but we will delay permanency a year, sometimes 18 months, even as long as 2 years. And again, when permanency changes to like guardianship or subsidized adoption or something like that, it can be reversed and go back to reunification efforts. So how do we get to case closure then? I just saw somebody ask, what are the rates in tribal court? You don't get paid. if you get appointed on a case, it's pro bono. If you want to represent a parent, a child, something like that, you would have to be paid by your client as a private pay. There are no court appointed, I mean, there are court appointed attorneys, but that's what our pro bono work is for. I don't believe that is the same in Winnebago, right, John? Don't, you can get court appointed attorney for criminal, and I think it's $90 an hour.
Yeah, I've never actually charged the court for what we do because, we're legal aid and, we got our own funding. But no, I mean, you're right. My understanding is, the Winnebago Tribal Court appoints you as an attorney to represent somebody in a case. There is a rate. And, I think also, I'm not sure about it, but I think also that the Santee Sioux Nation has paid private attorneys to take cases.
Sorry, just a moment.
Sure. And just going through some of the questions while Teresa is, building, whatever's happening there. We'll see if there's anything I can answer. But maybe Teresa's back.
I'm so sorry. I had someone step in the courtroom to ask me a question.
I know how that is.
And of course, now I lost my train of thought, but I see there's actually some good questions in here. So maybe I'll open that up and we'll have a look quick, John. I'd hate for us to run out of time and not get to,
Teresa, I can read some of them out loud if you'd like.
Sure.
Okay, the first one is, how do you handle placement preference if the parent objects?
Have you run into that, John?
You're muted. John, you're muted.
Thank you. I haven't run into that, or at least off the top of my head, can't recall that situation. But I mean, as an attorney, I guess what I would do is I would look at the code and the placement preference that is present in the code and see if it has a provision about what role would a parent play in determining, I guess, whether a particular placement should get preference or not. And I guess off the top of my head, I'm not certain exactly what that would say, but that's where I would go to try to answer that question.
And DHHS, in all the departments that I've worked with and tribal courts that I've worked with, I mean, they work directly with the parents. If the parents are saying, hey, this person is appropriate, even though they're higher on the hierarchy list, they're not appropriate. If they give evidence of why, like, I'm sorry, my mom's just not appropriate, here's why. Or the court can see with their own records that the grandparent isn't appropriate. So it's not like an absolute, you have to place with a parent. Well, that wouldn't make sense, right? That doesn't make good sense. We just remove from a parent. So it's not that the hierarchy, you have to do this, this, and this. If the grandparent's not appropriate, then we go to the next one and the next one and the next one. But those people, the people who are being skipped on the placement hierarchy, they can request a placement hearing. And we had a case where I believe it would have been parents that were requesting placement hearings saying, hey, the tribe didn't follow their own placement procedures. And it was a very long drawn out process. But yes, we have had parents come in and say, this placement isn't appropriate. And that's listened to and taken very seriously. And the tribe does have a responsibility to maintain Indian children in Indian homes as much as possible. It's not always possible. I think it is possible here a lot more often than it is in.
Yeah, and I mean, over the years, like I've seen, particularly, in the Winnebago Tribal Court, like I've seen, Patrick Runge, the judge there, enters orders in which, he's analyzing the placement preferences, And sometimes, he has determined, okay, we got to place him what the placement department says. Other times he said, well, for these reasons, I'm deviating from them, there's a good reason to. And so, yeah, it always is, a case by case analysis in that respect.
And frequently, judge will leave it in the department's hands for that placement. They'll just say placement with Department of Health and Human Services with a relative, or will state a specific relative sometimes, or foster, or something like that. But sometimes it's the department's job to then go out and find that relative and that placement. But again, that the placement who's either skipped over or who's chosen could come in, or the parent could come in and request a placement hearing.
The next question is, how can a CASA volunteer get involved?
Come up here to our court and we'll get you signed up as lay counsel. I think that's how that would work for a CASA volunteer to be. I assume that they are meaning to be appointed to represent the children. So, yeah, just come on up here or call us. Clerks will send you out an application for admission.
Next, is the customary adoption an option only available in tribal court?
Well, I guess I don't know what happens around the entire country, but from my perspective, what I'm seeing, customary adoption is only available in our tribal courts. I guess I am unfamiliar with anything that would allow that for anyone other than an Indian custodian.
Yeah, I think that there might be some examples other places in the country in which, there's a, particularly, collaborative relationship between the state and, tribes or tribal entities in that state. And, I wouldn't, say definitively that that's something that wouldn't be possible somewhere. I see there's a comment that, that's not a permanency objective in Nebraska State Court. I don't recall ever seeing it as one in Nebraska State Courts, but perhaps it would be other places.
What are the criteria for tribal courts to ask for a case to be transferred from state court?
I'm going to assume you're talking about a child welfare case. Basically, the Indian Child Welfare Act, from my perspective, and I am not our Indian Child Welfare Act expert attorney. We do have our own ICWA attorney who works here. If it's an Indian child, the tribe at this point has a right to intervene. It's not may they intervene, not maybe. They have the right to intervene if it's an Indian child. Well, what does that mean? The child's either enrolled or eligible for enrollment, but that just gets you intervened. The next step would be transfer. At some point in the case, the tribe, after they've intervened, may ask to have the case transferred to tribal court. And there's a lot of arguments, and Brackeen was just a couple of weeks ago in the Supreme Court of what will that look like moving forward. In the past, basically, if tribes asked to transfer, the transfer happens. It would be very, very, very rare that it would not be transferred to the tribe. And there's only a couple of exceptions for why it would not be transferred to the tribe. One, if a parent objects and says, no, I don't want it transferred to tribal court. That one's pretty much, that leaves us dead in the water if a parent objects to it being transferred. But that's not normally the case. But there can also be a best interest of the child argument made. Those have not been particularly successful, at least in my practice when I practiced over in Iowa and represented parents and children. They were almost always transferred. John, you probably have some thoughts on that.
Well, I think it's, I think that those requests don't initiate at the tribal court. It is, in my experience, the tribe, the tribes, ICWA department, which I think, at least in Nebraska, is, part of, the tribes, like Department of Health and Human Services, the Child and Family Services, they meet and they make those decisions. And I think each tribe has their own criteria about, when they're going to make that request. but I think those are departmental decisions, at least in my experience, that are made. I think that, then they find, something with the tribal court, and the tribal court makes the decision about whether they would, accept transfer of the case should the state court then decide to go ahead and transfer the case. Usually, in my experience, that happens before a request is made to the state court, because it wouldn't make sense to ask state court to transfer a case if you didn't know that the tribal court, was willing to accept it if it was transferred. And I mean, I don't know, there might be statutes governing that process internally within the tribe's Child and Family Services Department. I think some of those criteria might be more departmental policies that I guess would be internal to the department. At least that's
We have time for one more question. What can we as attorneys in state court do to get tribal representatives to be more responsive? Acknowledge our request for tribal transfer.
I'm not sure I understand the question completely, because the state court can't force a transfer to us. We can request a transfer to our court and accept that transfer. We're a court of limited jurisdiction. We can't be forced to take jurisdiction of a child that's not residing here. And if the child was residing, would have started here, and there wouldn't be an ICWA case. Was there any clarification from that question asker? No.
Yes, we can't get people from the tribes/tribal courts to acknowledge our communications.
I'm not sure that, I have a great perspective or the right experience to be able to answer that. And I've heard others who have experience, working, with tribes, ICWA departments. Talk about how they get like literally hundreds of those, communications in, a month or, something like that. And I think that there's, a lot on, these folks' plate. And I think that could be, informative into understanding that if that's happening. I guess what I would suggest, and I don't know, I hope I'm not speaking out of turn, but I don't work for, I don't work for the tribe, I don't work for those agencies, is, if you want to develop a more close working relationship with, a particular, arm of the tribe, is to try to devote resources to reach out to them and to develop those relationships, which is something that may not be easily done. It might take, significant, dedication of resources. See, I don't know if you could, set up a meeting with somebody and see if somebody could make time to meet with you and, talk to them about, the issues that you're having, and, see if there's something that you could do that could make, the response that you're hoping for, more easy. At least that's a suggestion, though.
Yeah, and again, I'm not 100% sure what part of the process you're talking about or asking about. If it's a family service matter, I can't. I can't give you any information. There's no information I'm going to give to any attorney or state representative or I can't give you any information. If you're talking about response to whether or not a child is eligible or not, and ICWA applies, that's almost always the enrollment office's responsibility. If you're talking about the ICWA attorney who has intervened, I guess you would just reach them directly like you would any attorney for a party. Well, I don't have a lot of information about Rosebud Sue. I know that was the question with Shirley Badwound. So, if anybody wants to reach out to me to ask questions about that, it's teresa.rachel@theomahatribe.com. I apologize, I my tribal cell phone number memorized. But I'm so glad you all came and attended, and I hope you consider applying to practice in any of the tribal courts, all of the tribal courts. It's very cheap. If you've got companies that just started with you, we want to see them. If you've been practicing for 50 years, we want to see you too.
Well, Teresa and Jonathan, thank you so much for presenting today. We are so appreciative of your knowledge and insight. Following the webinar, attendees will receive a Qualtrics survey. So we would appreciate any feedback that you can provide, as well as any suggestions for future webinar topics. A link to the CIP website with the resources that were referenced in the webinar, as well as a copy of the PowerPoint presentation that was shared, will be included in the email. And the next CIP webinar discussing 2023 legislation is on February 9th from noon to 1 Central. And this annual webinar brings together experts to discuss bills related to child welfare, youth justice, education, and any other topics that are relevant to children, youth, and families. And registration will be sent out in January. So thank you all for joining.